The issues of inclusivity and representation in the judiciary are pervasive across legal systems in Asia and around the world. They take an even greater significance when courts and judges face legal dilemmas implicating ingrained systemic biases and dominant societal values. So in this episode, we will delve into these issues with the first woman to be appointed to the Supreme Court of Pakistan, Justice Ayesha Malik. Before joining the Supreme Court, Justice Malik had a distinguished career as a judge on the Lahore High Court for a decade. Now, while her appointment marks a significant progress towards gender equality in Pakistan, there remain challenges ahead. And in this episode, we hope to shed some light on those complexities.
Welcome, Justice Malik. It's a pleasure to have you on this edition of Chai Chats. I think I want to start by asking you about your role as a woman Supreme Court judge. So your appointment was the first on the Pakistan Supreme Court, and
That's
that was
correct.
a very significant appointment. I wonder if you can talk a little bit about the significance of this appointment, of having a woman on the Supreme Court of Pakistan for the very first time.
Well, first, I'd like to thank you for inviting me. And I think it's going to be an interesting discussion. So my appointment to the Supreme Court was the first appointment of a woman to the Supreme Court in our 75-year history. It was not an easy or smooth journey to the Supreme Court. It was a highly contested appointment process. But eventually, it's now today, I've been here for 2 years. And in order to answer your question and to sort of appreciate why it's important to have women and why I'm like 50 years late in the process of appointing women to the Supreme Court, is that let's just look at some demographics. Women represent approximately 50% of the population. Women in the judiciary, approximately, say, about 17%. And women in the higher judiciary, which means the High Court and the Supreme Court, is approximately 2%. And I'm being generous with my figures. I'm being generous. So right off, I'd say it's a disproportionate representation of women in the judiciary versus the population at large. So 50% of your population is represented by 2% of the judges in the High Court and the Supreme Court. So the impact that this has is the biggest impact that this has is that there is an absolute lack of a gender perspective from the bench in judgments, in the judicial processes, and even within the institution itself. And that means that there is a lack of an understanding of issues from the point of view of a woman, which is important. It's important to understand the right as it is enforced on a woman, her experiences, what is missing in the enforcement of that right. And that, I think, is the biggest challenge that you face when you don't have women on the bench. The second issue is that there is a lack of gender sensitivity in the system. So the system's response to women is not as sensitive or as appropriate or apt as it should be, because primarily it's a male-dominated system. And the male-dominated system responds in that traditional cultural way with women. So it's difficult for women to access justice and to access the court processes, which is one of the biggest barriers that women face when they have to come to the court. When you have women sitting in court, when you have women lawyers, when you have women prosecutors, when you have women who are part of the justice sector, then you bring in more and more of the gender perspective into the system. You start working with gender sensitivity and make the system more conducive to women. But if you don't have that, and if your percentage and your numbers are very low, then the response is also very low, and the way in which the system will catch up with the population, the growing population, will be very slow. And the result, in my opinion, will become frustrating because you're not really responding quick enough to the women. You're not responding appropriately to what the women want. So I think it's very important to really look at how we should bring women into the justice sector and women as judges, because you do need the gendered perspective in the courtroom. You need more women who will be able to understand the impact. It's not just about cases pertaining to women, it's about all cases, economic cases, cases which talk about financial independence, which talk about how policies unfold. The way it will impact women will be different from the way it will impact men. And I give an example with the recent floods in Karachi last year. There was a case before the Supreme Court where the High Court had interfered in the manner in which relief was being distributed to the victims of the flood. And the first thing that came to me was that there's no woman on any committee that the High Court had set up. And consequently, the issues of the women victims were totally neglected. And women suffering in those camps from just getting medical attention was not brought to anyone's attention because you don't have women there in the decision making process looking at things. So that's just one way of looking at the relevance and the significance of bringing women into the judiciary. I'm happy to say that now we are two in the Supreme Court, and I'm hoping that the number increases. And I will be able to say that, we are all women, or at least we're 7, 8 women in the Supreme Court.
I wonder whether I can just ask a quick follow-up, which is, would you be able to recount one or two personal stories, either as an opportunity or which presented itself as a challenge, where you had to deal with issues of gender or women's rights or any other issue of social cohesion, where your role as a woman on the Supreme Court gave you some added leverage?
Right. So I think the biggest challenge that I have faced is that of acceptability and acknowledgement. When I was appointed at the High Court, I was the only woman there. And it took a considerable amount of time for the litigating public, the lawyers, the court itself to get accustomed to the fact that now there is a woman on the bench, and that this woman is not even subscribing to the traditional role of just doing family cases, but she's like getting into the hardcore issues, or the sort of maybe non-woman issues, you want to call them. And so it was a challenge. And sometimes the challenge even now exists when you don't necessarily have a lawyer looking at you. It may be just out of respect because culturally that's what he knows, but he's not looking at me. So I'm not getting the satisfaction of being of knowing that I'm being acknowledged or being on the bench. So I'd like to say that these challenges, I think, and the way the system responds, this is an evolving process. And
Right.
you get lots of different, stories and situations, from being asked, will you only do family cases? Do you go home at 2 o'clock? Is your courtroom pink? Do you need a female staff? To doing, the work itself and being told you're the best male judge on the court, or that you're a bold judge, or that you write good decisions. It's sort of, it goes both ways, and it's how people perceive you because it's how they perceive women. But I would say that in my journey of 12 years, I've seen a marked difference in attitude. These are people outgrowing traditional and cultural habits. You can't expect it to change overnight because you're ready for that change. You have to give people time and space to change. And it's good that it's changing. The other important thing is that with more women coming into the profession, this dialogue has opened up more. This conversation takes place more. So you're able to have a more direct conversation on the issue. So, for example, I will be able to stand up and say that, the institutional framework has to be looked at. You need to create safe spaces for women. You need bathrooms for women. You need chambers for women judges. You need, sitting areas for the women litigants. So this conversation now is right there. It's in front of everybody. And this is something that I think with time will become difficult to avoid. So these are some of the challenges. The opportunities are numerous. Just by being there, you make a difference because you are now hearing the stories of these women or the litigants, and you're able to put a perspective to that story, particularly in cases pertaining to women. So I think the opportunities are endless. You have a voice, and your voice can be
Right.
heard. And that's how I perceive myself and my role, that I am that voice that will call out the stereotype, the discrimination, that will say that you need to change the way we're doing things. I always say we have to reboot. We have to reboot the
Mm,
system and bring in new policies and bring in a new way of thinking, which I think is relevant because we have to understand that I don't want someone to make decisions for me. I want to
right.
be part of that process because the people making decisions for me are not of my gender. So they don't necessarily understand what I'm saying. And that doesn't mean that I should be put in a place where I don't belong. It just means
Right.
that you have to hear me out. You have to hear me out. That is
Mm.
now the new challenge that I'm not here just to fill up a number. I have a role to play and I should be able to play that role.
I like the positivity that you've taken to all these challenges because you're faced with this ingrained social attitudes and stereotypes that obviously bleed into the courtroom as you were putting it. And I guess it's easy for people to say, uh, these are this is difficult, the society is like this, and they then start to criticize the society. But as you rightly said, um, things cannot change overnight because that's how people have functioned for decades or even centuries. So that's really, really profound, I think. Perhaps we'll come back to some of the gender cases later, but I want to pick your mind on the judicial role, because conventionally the role of judges is often understood as revolving around interpreting and applying the law. Uh, but in your opinion, from your experience, is it always straightforward, especially when you are faced with cases implicating the norms, practices, and the idea of justice in the society?
No, it's not straightforward at all. For one thing, the one of my roles in a constitutional court is to interpret fundamental rights. And when you interpret fundamental rights, the right to equality or the right to life, the right to dignity, or to protect someone from discrimination, you automatically bring into that the social aspects of what is undermining that basic right from becoming an absolute right or from culminating into a positive right that they can enjoy. So you will automatically bring those issues into the courtroom because you're talking about inherent issues that are there, that exist in society, which is why people come to the court saying that my basic rights are not being enforced. So a constitutional court is basically in the Supreme Court is the guardian of all fundamental rights. So in my role as a judge, I will look at all aspects of what is coming in the way from enforcing that right, because my objective will always be to enforce the fundamental right and to translate the process into such a way that it allows that right to be easily enforced. Our constitution also has a unique feature which is called principles of policy. And in principles of policy, we're given general guidelines of what we should look at, in which a lot of these social issues are mentioned, like making sure that women and children are protected, discouraging prejudices and discrimination, protecting marriages and family, the mother and the child, protecting the minorities. So there is this whole chapter, principles of policies, which we don't enforce as of right, but we use it as a guiding principle. So even
Right.
that means, in response to your question, it means that it's not just hardcore law that will
Mm,
be interpreted, but these things will kind of creep into the courtroom, into the judgment. And it really depends on the judge and how the judge looks at the issue to see how much relevance will be given to those aspects.
mm. Could you perhaps share with us maybe one notable example where you have had to navigate these different considerations in your judgment?
Sure. So I have many examples, and let me start with a more recent case that was decided in the Supreme Court in a judgment that I've authored, and that pertains to the issue of land acquisition. So we have a long history. Pakistan has a long history where government is able to acquire land forcibly, pay compensation to the landowner, and do whatever government project it requires to be done on that. And as a High Court judge, I saw that this is a highly disputed area. So you have landowners who have some land that they've, spent their lifelong earnings, and they've acquired, they bought the land, they are doing business on it, or they want to do something on it. And suddenly it's just acquired forcibly, and there's very little they can do about it. And the general response of the courts will be that, all right, there's compensation to be paid to you. So you now dispute the amount of the compensation that you're being paid. And so, the cases started going in the direction of compensation and how much compensation should be paid to the landowner. So when we looked at the issue, we gave it a very different sort of holistic view and changed the composition and the way compensation is paid. Because the idea in my mind was that this has to stop somewhere. And until they don't want to change the law, how do I plug this problem so that people stop litigating? And secondly, the government does its job before it goes around acquiring land. And so to do that, we made the compensation process sort of more of a burden on the government than on the landowner. So we worked in such a way that it was for the benefit of the landowner. They would be getting the maximum value that they could get for the land, because the court ruled and said, you have to keep in mind this is their fundamental right under the Constitution. Their life may be dependent on it. They've spent their livelihood collecting this little piece of land. You can't take it away, and if you do, you must pay the potential value of that land. And potential value will include not only today's value but any futuristic value that may be attached with that land. And I'm happy to say that as a consequence of this judgment, I can see the difference, because the government will now have to really think about what land it's going to acquire and the fact how much compensation is going to have to pay. If you have to pay someone, for example, $10 for every acre that you're taking, as opposed to today we may say $500, that's a very big difference. And they can see that the court now, with this Supreme Court decision, will lean on the higher side because potential value. So that's how you look at it. You see a huge social problem of where land is taken and there's really nothing you can do about it. No change in the law, is visible right now. So this is how you sort of plug the problem in this way. And if I can just give another example, when I was in the High Court, I was looking at a case which involved farmers growing sugarcane, was selling sugarcane to the sugar factories for manufacturing sugar. And again, this is an area that's heavily litigated because the farmer does not get money for the sugarcane that it sells. And then, by looking at the law, looking at the issues over years, I discovered that there is an imbalance. The law and the rules made don't really favor the farmer. And again, you don't see the law being changed. You don't see any desire or will on the side of the legislature to even address the problem. So in a way to kind of plug the problem, I thought of a way, what can I do as a court to protect the right of that farmer? And I created a system where I said that the farmer, being the owner of the sugar cane, will retain his lien on the sugar cane even when the product becomes a lollipop or a biscuit. That the lien will remain on the amount of sugarcane that's gone into that lollipop or that biscuit until the government pays it. So in that way, the right of the farmer was always protected. And even though a sugar mill was borrowing money from the bank, and you had all the banks come in to say, I have the first right as a creditor because everything's mortgaged and pledged with me, now the right of the farmer was put above that of the bank. That judgment was upheld by the Supreme Court, and it has literally reduced the litigation. It has
Wow.
reduced the litigation. So once again, it's a way of giving to that poor farmer who, had no choice but to sell his sugar cane to a given sugar mill because that's what the law requires, and yet was not being paid for it. So this is how you can make a difference. And maybe I don't know if I will be saying a lot, but maybe it's the gender that makes you look at the problem in that way
Hmm.
to try and resolve the issue.
I think that's fascinating, Justice Aisha, because it's not just about the right that the person has or a money issue, but what I'm gathering here is that you reduce litigation, and also these decisions have the impact of increasing government accountability, because now the government has to act.
That's right. Absolutely. You not only want the government to act, but as a constitutional court, you also nudge them. So in the land acquisition case, we gave a finding and said this is an archaic law. This is a law from the time when the British left, or rather, they came and they needed to acquire land to build infrastructure. We are way beyond that stage. So the law has to change. And we've given directions that change the law. But you see, to change the law, you need the lawmaker to have that will to want to change the law.
Mm.
The courts do respond to these issues, do look at them, and do look at a way of trying to sort of fill up that gap if it can, or at least give some sense of direction to the government that in the future this is a better course of action for you.
I think those two examples are very interesting. I want to move the conversation now onto the suo moto jurisdiction of the court. I understand from Article 184 of the Constitution, the Supreme Court does have the capacity to initiate cases on its own. I wonder if you can speak to us a little bit about some of the tensions and some of the challenges in exercising this jurisdiction. And maybe you can also provide a few examples of how the court has used this jurisdiction.
Right. So this is a jurisdiction where the court of its own motion can initiate proceedings and start looking into a matter. And it can be on the basis of something the court has heard on the television, read in the newspaper, a letter that is written. Now, traditionally, this is a power that has been exercised by the Chief Justice, where the Chief Justice just initiates the proceedings on something that they have heard or they've read or they look at and they see that it's grossly impacting the rights of a large number of the public. So from the terrorist attack on the schools in Peshawar with the death of a large number of students, where the court felt that not enough was being done in the investigation, so it took suo moto action, to attacks on minorities when their colonies were set ablaze, to relieving the bonded labor that was, bonded to their landowners and had literally sold their lives and had no choice. The Supreme Court has played a role in developing jurisprudence in its suo moto jurisdiction. Now, while on the one side, there's been some good positive results out of this jurisdiction, over the years, it has sort of snowballed in the sense that it has been used in many different ways, which became a subject of disagreement within the court, which became a subject of discussion outside the court, where everyone was now wondering whether the court is exceeding its limits, whether the court is encroaching upon the jurisdiction of other members of the state, and whether this is something the court should be doing. So of late, what we find is that internally, there is no sort of consensus on how this power should be exercised. And even externally, I would say that it's something that's not going to be easily accepted. At the same time, just speaking from my own experience, when I often go and address students, I'm usually questioned on suo moto a lot of, why we did suo moto in this case or that case. And while they're critical of it, they'll also at the same time bring up four relevant issues and say, why aren't you exercising suo moto jurisdiction in these areas? So from that, I would say that, I think everybody's a bit unsure of how they want the court to respond and what is it that the court's role should be. The court then recently gave a judgment where it held itself accountable and regulated this jurisdiction by saying that now it's not just something the Chief Justice can do, but two senior judges have to sort of write to the Chief Justice to say, this is a problem, this is an issue, maybe you want to exercise suo moto jurisdiction. For me personally, I think this is an exceptional jurisdiction, and I would be very cautious and careful in exercising this jurisdiction. That while good can be done, you can easily encroach upon the powers and the authority of other stakeholders and other actors of the state, which then really leads to the question of what the role of the court is and what the role of judges is. So I think in today's Pakistan, this is a jurisdiction that cannot that easily be exercised without very, very good cause and without possibly the backing of the entire court.
Do you draw at all from other countries' experiences with suo moto jurisdiction? Has that been helpful?
I think initially we did draw, but I think now this is something that the system itself is questioning. So judges are also questioning it. For me, the question is, where do I draw the line? Where do I say this is something I should interfere in, but this is something I should not interfere in? And while it seems like you can try and devise some rules for it, I think it's really going to be a personality thing. You know, someone will say, I think this is worth interfering in, and someone will say, I don't think this is worth interfering in. I will be very cautious. I think judges are there to adjudicate on disputes brought before them, and there has to be some very compelling reason to persuade someone like myself to exercise this kind of a jurisdiction, not because I don't think it doesn't bring good, but because of the way in which it's been exercised. I'm not able to justify it. And like I said, I'm not able to draw any strict line and say, this is the line I won't cross, but I'll stay within this line. So until there is clarity on that, I would say this is an area that needs more understanding now. We have to revisit this as well.
So, Justice Ayesha, you have presided over significant cases concerning women's rights and equality. You alluded to, I think, a couple of examples earlier. But there's also a couple of examples that I want to highlight here for the benefit of our listeners. For instance, the virginity test case, where the court ruled that the two-finger test for female survivors of rape and sexual abuse is unconstitutional. And then the court also ruled that a mother's remarriage does not disqualify her from retaining custody. So from your experience, how do you incorporate gender perspectives into the judicial decision-making process for these sorts of cases? And what are the challenges around that?
So for me, writing a judgment, it's like narrating a story. I'm narrating her story. And when I'm narrating her story, I'm trying to bring her point of view into the judgment, particularly when you're looking at gender-based violence, harassment, custody. I'm trying to bring in her perspective into the judgment because that's the perspective that I think is totally missing. So all judges decide cases as per law, and they all rely on the facts. But the difference between a woman judge and a male judge is how you look at those experiences, how you understand social issues and problems, or what manifests into problems. What are the areas you highlight? I may give emphasis to one particular aspect of an issue, whereas my colleague might give emphasis to another aspect of that issue. At the moment, I would say the scales are lopsided. My aspect of the issue is totally missing from the narrative. And so when I write the judgment, I try to bring that narrative into my judgment. I try to bring in the barriers. I try to explain the thought process for the woman, why she had to do what she did. The two-finger test judgment is an example of that, because while I was writing that judgment, I felt like the victim. I felt that I was being intruded. I felt my privacy being invaded. And I could not understand and relate to the fact that this test was necessary given medical science, given DNA testing. I just couldn't understand why anyone would want to do such a thing. So it became, I could feel that what a woman would be feeling at that time. And post judgment, often in conversation, many of my male colleagues and other people who are involved in dealing with rape cases would tell me that you don't know how to respond here, because these are not the kind of cases that you work with. And my answer to that would be, that's fine. I may not have spent my litigating rape cases, but then you don't know how my anatomy responds to things either. And how can
Mm.
you tell me something that biologically and medically makes zero sense? And my biggest thing in that was that by doing a two-finger test, while may give you some results for a virgin, but certainly not for a married woman, or a woman whose hymen is ruptured for any other medical reason. So what does that mean? What impact will that have on married women who are raped? So that's one aspect, one way of looking at it. The other way of looking at it is that when you bring in the gender perspective, when you start bringing in the narrative, it also helps to dispel the cultural and traditional way of thinking. And so the judgment that you referred to on the custody and women who marry a second time, this is again something that is culturally discussed a lot, and there is a general belief that women lose custody of their children if they remarry. Hence the pains the judgment takes to talk about the religious aspect of it, the international aspect of it, and then looks at what in our law is relevant is the welfare of the minor. So I take pains in explaining that welfare is not about just giving money, providing a house, sending the child to school. It's about safety. It's about how the child feels. It's about the comfort of the child. It's about the environment that you create. And that's me as a mother speaking. I'm looking at all the things that I think I bring into the home that give my children comfort. And I think that's important because, from a man's point of view, he's the provider, he's giving the money, and he thinks, I've done my bit. But I'm saying, no, today, the welfare of the child also involves their mental health. If you're not looking at their mental health, then you're ignoring a very relevant factor of today's world. Children face serious mental health challenges, and we can't ignore them. And so you have to pay attention to that. And that's a these are the ways in which you bring the gender perspective. I'd like to bring in one more judgment which kind of again highlights the point, and that's on harassment at the workplace. So there was a judgment that was given by the court, all male judges, that harassment at the workplace means some element of some sexual act, and sexual act will mean an act of sex.
Right.
Now, for me as a woman, I'm thinking, wait a second, I don't have to be harassed, sexually to mean only that it has to be physical. I can be harassed in the way someone speaks to me, or the way someone looks at me, or the way someone, insinuates something, or there can be numerous circumstances, and that we have to look at that. So I was fortunate that the review came of that judgment, and I got a chance to sit on the bench and revisit that judgment. And so one of the challenges I faced was that the other judges who had originally given that view also sat with me. And I was told that, it's not likely that we're going to change our minds because we've given our view on the judgment and we think our view is correct. And they said, but you write the judgment because you feel so strongly about it. And I'm happy to say, this is one of the opportunities that, we talked about, that when I wrote the judgment, I put in a lot of my sort of gender passion into the judgment. And and my colleague said, you know what, you're right. We kind of didn't get the point. And by reading your judgment, we understand what you're saying. And you're right. Your view is the correct view. And this is, so they all signed off on it. And that's exactly what the gender perspective is all about. There is a role for women to play, and this is the role that they can play, and this is the impact that they can have. So This is not something that would be unique to me. This would be the story of many women who can make a difference in this way.
I just want to move on to the question of public opinion now, and look at how public opinion and the courts kind of engage with each other at all. So this is a two-part question. One is, does the court at all, is it influenced by public opinion when it gives its judgments? That's the first part. And the second part is, what do you think the public perception is of the Supreme Court of Pakistan? And is there a gender dimension to that public perception?
Right. So the court does not formally engage on social media at all. The court technically would say, they're not aware of what's going on in social media. But social media is a very big part of our present today. It's a way of, information, opinion making. It's what you see. So I can't say that as a court we would be influenced by social media, but I would say that individual judges would have their own take on how they want to view social media, how they want to respond to social media, because now it's no longer the conventional sources of news that is just the television or just the newspaper. Now it's a whole new ball game, and a lot of it maybe people of my generation don't necessarily even understand that how this public opinion becomes this thing that's literally in your face now. You can't sort of escape it. I personally think it's a good thing. I think it's a good thing. It's a good way of holding people accountable. It's a good thing of getting conversation going. But at the same time, I think it's important for social media and people who form opinions on social media to also mature into that opinion making concept. So I encourage young students and the youth to use social media, but I always tell them use it from a point of information and knowledge. Don't go on social media and pass opinions on things that you have no knowledge about, that are not your personal opinions, but based on what other people are saying, because then you start disrupting the system. So at the moment in Pakistan, I'd say if I could measure us on a scale of 1 to 10, I'll say we're around a 5 in public opinion. There's not a lot of the level of trust and confidence is not where it should be. It has eroded over time, and social media plays a role in that. And I think one of the factors, recent factors, that has enabled more of the youth and other members of the public to see what the court is doing is the court going live in some cases and putting itself out there for people to look at. So naturally, you go live, you invite public opinion. So, I am not a young person, but maybe a younger judge. I'm all for social media. I'm all for, the youth engaging and giving its opinion. But I think that opinion making process has to mature as well, and there has to be some sense of responsibility on how you disagree with judges and judgments. You don't have to be rude about it, you don't have to be personal about it. You're welcome to disagree with my opinion, but there is a way to do it. So I think we are all evolving and possibly moving in that direction, and it would be interesting to see how more evolved societies initially dealt with this issue, because we're definitely going through that process of learning the good and bad of what social media does when it comes to forming public opinion.
A concluding question, and this is really on comparative law and the value and usefulness of comparative law. Does the Pakistan Supreme Court rely a lot on comparative jurisprudence? And beyond judgments, do you talk informally to other judges at conferences and symposia?
I think I won't answer for the institution as a whole, but I would say that a lot of judges do rely on judgments from other jurisdictions, and some have favorite jurisdictions. I personally, I rely on judgments from other jurisdictions. But what I've now recently started doing, because I also, along with the gender perspective, I also promote the Global South perspective. I think it's time that the Global South develops a perspective and a narrative of its own through its own literature. And for that, what I've started doing is looking in-house. So I encourage local academic work. I encourage the academia to write, and I bring that into my judgments, because I think it's important to look at what experts say on certain issues, particularly issues that border on social and social political, contours. You have to see what the experts are saying. So the harassment judgment does that. The harassment judgment looks at what local academics have written on the law, have written on what harassment means, and how they have explained how harassment can't be just physically sexual act, but has to be something else, and why it has to be something else. And the judgment also is uses comparative jurisprudence, and looks at different jurisdictions around the world to see how they have perceived and how they have looked at harassment. So I think it's a good thing. It's good to engage, and I definitely like engaging with the academia. I like engaging with other judges, because I think it helps me in my thinking process. Otherwise, I can't necessarily know everything, and the only way to understand things is to see how other people are looking at it. I think conversation and communication is vital for judges. We have the traditional model of judges who sit in their rooms quietly and don't engage with anyone and just write their judgments. But today's judge has to engage and has to look at what is happening around them, so that their judgments have impact, so that their judgments make a difference, and so that their judgments respond to the issues they're trying to address, particularly in countries like Pakistan.
Thank you, Justice Ayesha. This has been a really inspirational and profound conversation that we've had so far. But perhaps I want to ask you one concluding reflection, a non-law reflection, if you will. What drives and powers you throughout this journey as a judge? And if there is someone out there, or a group of, say, young ladies out there aspiring to become a judge, what would your advice be to them?
I've been a judge now for more than 12 years. I believe my journey, it's given me time to think, reflect. I've evolved from looking at things in a way where sometimes it would disturb me. I would, I would feel pulled down. Whereas now I give a positive spin to things. I look at things positively. I want to have impact, and I want to be remembered as the judge who told a story that anyone could relate to. I think it's important that young people, they are our future. And I think it's important now for young people to think about what their contributions will be, what their legacy will be. And I always ask, and I think that's what drives me as well, is how do you want to be remembered? How do you want people to think of you when you're no longer there to defend your judgments, to explain your judgments? How do you want people to remember you? What is your legacy going to be all about? And that's really what drives me. And when I write judgments, my objective is always that it should be something that anyone can understand. I'm not writing it for a particular audience. I write it for people to read and understand, so that even the litigant in whose favor or against whom I've written the judgment, they can read it without having the lawyer to translate it for them. And I think that's really because my whole concept as a woman, as someone who wants to be visible, as someone who wants to be acknowledged, is about that voice that you want heard, that voice that you want understood, and that voice that you want imprinted and integrated into the system. So that's the driving force. If you want to be a voice, then you really have to persevere, and you really have to keep working at it.
Well, thank you, Justice Ayesha, for this really interesting and fascinating conversation. It's been a real pleasure for us to be able to talk to you, and hopefully our viewers, well, I'm sure our viewers will also, and listeners will also gain a lot from the perspectives you have shared. Thank you so much for joining us on this episode.
Thank you very much. And I've enjoyed it. Thank you very much.